So, good morning and welcome to our Dementia Action Week 3-question podcasts, where we are asking the 3 questions that we feel are the most significant when it comes to dementia from a variety of specialists in various areas. And today I am delighted to welcome Katie Hindmarsh, who is the Senior Solicitor at Walker Foster Solicitors in Harrogate. So, welcome, Katie.
Hi there.
Hello, I'm just going to introduce you. I know that you are a private client solicitor at Walker Foster Solicitors and you specialise in wills, probate, powers of attorney, deputyships and trusts. You do a lot of stuff there. You're also a member of the Association of Lifetime Lawyers and the Society of Estate and Trust Practitioners, and that you qualified as a solicitor back in 2019, and you have spent your whole legal career practicing in North and West Yorkshire. So I know that you're incredibly busy today, Katie, so thank you for taking the time to speak to me. We know that legal documents are incredibly important to have in place during our lives in general, but this becomes even more so when a person is diagnosed with dementia. Can you just let us know, Katie, why is it important to have a will, and does this become more important when we begin to live with dementia?
Yeah, so absolutely. So first of all, thanks very much for having me on. Sorry, I think I've maybe done a typo when I've given you my bio. It's 2009 that I qualified, Fiona. Sorry, not 2019. But yeah, so with regards to wills, we advise all of our clients to have a will. And the idea is obviously that we're making sure that our assets pass to whoever we actually want them to when we pass away. So when we say assets, what we mean is anything that you have that's in your name, so bank accounts, property, personal belongings, such as a car. And the idea is that you've got control of what happens when you pass away. And some people don't think that they need a will because they think, oh, I actually haven't got much myself. But you should also have consideration about possibly inheriting money from family members, parents, that kind of thing, and where you'd want to direct those assets. And it's just to kind of get an awareness out there as well, Fiona, that some people think that if they're married, they don't need to have a will because their assets would just pass to their spouse. But that's not the case. There are these rules called the intestacy rules, which are basically legislation that's set out, but they don't necessarily work the way people think that they would work, i.e. your spouse wouldn't automatically get everything that you own. It very much depends on the value of your assets and who survives you. So that's why it's critical to have a will. And it's also important to remember as well that there's no such thing as a common law spouse. So a lot of people think that, oh, well, I've been with my partner for a long time. Actually, it doesn't matter. If they're not in your will, then they won't get anything. We'd also want to get the message out there that it's really important to speak with a solicitor or legal practitioner rather than trying to make a homemade will. Because we can give tailored advice that's relevant to your circumstances. And homemade wills can easily go wrong if they're not completed correctly. So when I say homemade will, I literally mean the pro formas that you get from Smiths or online. They can go badly wrong, and we've seen it happen time and again, unfortunately. It's not very, it's not a one-size-fits-all process. It's very much an individual situation for people. So your legal practitioner will be able to guide you through the process, what you should be considering when you make your will. And quite often we have clients saying, oh, I didn't actually think about that. So it's important to have that kind of independent eye on your situation. And it's also has value having a legal practitioner, because if you have a situation where you're not including a family member for some reason, and that's not been given correct consideration, then that can bring claims at a later time. So it's really important to get somebody to have a look at it for you. It doesn't have to be costly. So there's law firms who do take part in free will schemes. So there are these avenues that you can go down. But there is value in having a legal practitioner look at things rather than just trying to do it yourself. And they can assist with legal, like I say, any kind of claims against the estate or inheritance tax planning and that kind of stuff. So yeah, there's a lot of value in getting it looked at properly. So we would just be encouraging anybody who's got a diagnosis to be getting their affairs in order as soon as they can, basically.
Yeah, yeah. But I think it's crucial, isn't it? I think we put all of our financial stuff on and all our legal stuff on the back burner, waiting for the right day for it to happen. And I
Yeah,
suppose the right day is kind of today. Um,
absolutely. Yeah.
yeah. I mean, there's also a thing called lasting power of attorney. Can you just explain what that is, Katie, and why that is important to have, especially with a dementia diagnosis?
Yeah, no, absolutely. So these very much go hand in hand with your will. So your will deals with everything when you pass away. Your power of attorney deals with everything whilst you're alive. So lasting powers of attorney, there's two types, and they allow you to appoint an attorney to be able to deal with your finances or your welfare for you. So your attorney is that individual who you name within those documents. So very, very straightforward documents. The property and financial one deals with all of your finances, your property, your income, benefits, that kind of thing. And your health and welfare deals with anything to do with your health effectively. So where you live, down to things like medication, who can visit you. And both documents need to be registered with the Office of the Public Guardian in order to be used. So they're the body that are in Birmingham, basically, that supervises attorneys in England. The registration takes 20 weeks, so it's really important to get the documents done as soon as possible because that 20-week delay can really hold things up for family. So the way that they work is a health and welfare lasting power of attorney can only be used if you've lost mental capacity, and the financial one can be used as soon as it's registered. So we've got quite a lot of elderly clients who just say, "Oh, I've had enough of managing my debit, my debits out of my account. I don't want to have to deal with my utility bills anymore. Can you just sort that out for us?" So the property and financial affairs one is great because it can be used whether or not you've got mental capacity. And like I say, the health and welfare that one is to catch, to do with your welfare if you don't have capacity. And they're really invaluable. We're telling our clients, no matter what age, that they need to do them, because if you have a sudden accident and you lose capacity for whatever reason, then your family are really in a bit of a difficult situation. They don't have any authority to make decisions about your health or your finances without power of attorney. And the alternative to that is making an application to the Court of Protection, which is a really lengthy application process. You'd be looking at least 6 months to sort of get that through, and then you're going to have medical costs because you have to have a medical report. You would have to have lawyers really involved at that stage because it gets quite complicated, and then you've also got a court fee as well. Whereas the lasting powers of attorney, you don't have to have a lawyer make those. You can do those online yourself. They're fairly straightforward. There's a government website, and it's you can kind of follow the link through. So definitely would recommend people to do that as a kind of belt and braces, get your will sorted, get your power of attorney sorted. Yeah, the idea is that you've got control over who you appoint in your power of attorney, whereas the Court of Protection, you don't have control at all. That is an application somebody makes on your behalf if you've lost capacity. So at that point, it could be made by a legal practitioner or somebody, for example, in the council, or anybody really. So yeah, it's really important that you have that in place.
I think once again we have this misconception that because we live with somebody when we're married to them or we've lived with them for a long time, that this information would automatically be passed to them and they would be able to make those decisions on our behalf. But you go down a rabbit hole, don't you? If the decisions that they specifically instructed you with is contrary to what your healthcare practitioner decides, or we've heard of people who can't access money out of the bank from a joint account because one person has lost capacity. So it is really crucial to get this done, isn't it?
Yeah, absolutely. And the banks and things are really, they're sort of trying to cover their own back from them being sued by anybody. So I've seen situations where they'll freeze an account, they'll freeze a joint account, and you think, oh no, how are we actually going to operate this account? So it's really important that you get that done. Similarly, with the health and welfare side of things, I've had clients say to me, well, my wife's been terminally ill and the doctors wouldn't, speak to me at all. So it's absolutely invaluable for people to be able to kind of have these conversations, and they are grim conversations to have for people, and we completely understand that, but they're so important because the other side of it is being in a situation where you're distressed anyway, understandably distressed anyway, and then if you can't access somebody's money to help them, it's just incredibly tough for people. So yeah, absolutely. Yeah,
So
worth that
you
conversation.
definitely. So you mentioned capacity earlier on. Um, just tell us, Katie, is it too late? You must have people who come to you with a dementia diagnosis, and is it too late for them then to make a will or a lasting power of attorney?
So basically, the situation that we find ourselves in is that we very much required to make those kind of decisions on a case by case basis. And the short answer is no, it's not too late, Fiona. If it's somebody that's been caught their diagnosis early, they're still able to give us clear instructions about their will and power of attorney, then we're able to take those instructions. We would always see a client on their own anyway in those situations, so we always have to make sure that they're not being led by anybody, and we would always do that in any event. And if we've got any concerns at all about capacity, we would always refer to their medical practitioner or GP to do an assessment of capacity. But it's definitely not it's not a barrier in terms of it's worth that conversation. So even if you think, oh gosh, actually, I think I've left this too late, I would still have that conversation. We're always happy to see people for sort of free half an hour consultation just to chat things through. I mean, it may be that, if it's caught too late, yes, unfortunately, sometimes it is just too late, but it's absolutely worth having that conversation. And it's not yeah, it's not absolutely a write-off. It is
Mm.
definitely worth speaking about it and seeing if you can still go ahead. I'd encourage anybody who's a diagnosis to seek medical legal advice, beg your pardon, as soon as
Yeah,
possible. Yeah.
definitely. Yeah, I think the top and bottom of it is that we need to do this, don't we, when we have capacity, and not keep putting it off and putting it off, which is something that we just tend to do, don't we? That's but you've just mentioned there for all that stuff, that getting it put into place and just getting it out of the way, because you can update your will, you can change your power of attorney, I would imagine, if things change as you go through your life. And it would be really good if people could give you a ring and make an appointment and talk to you about this stuff. If people do want to contact you, Katie, can you just tell us what would be the best way for them to get in touch with you if they were to look to get their legal affairs in order?
Yeah, so if you ring our Harrogate office, the number here is 01423 224 342. And if you ask to speak to myself, I'll be happy to have a chat and make an appointment. Like I say, we're happy to see people on a sort of free half-hour basis just to chat things through. And like you say, it is one of those things. They're on people's to-do lists. Nobody likes talking about these things, but it's very much you kind of have to have it in your head, a bit like an insurance policy. Once it's done, it's done. They're in place, and you can forget about it. And yeah, absolutely, you can update your will. You can changing LPAs is a little bit more complicated, but you can do that. So yeah, it's much better to just get it in place, and once it's done, you can tick that off your to-do list and forget about it.
Yeah. I think what we need to do is just speak to a specialist like yourself, Katie, get it out of the way whilst we all still have capacity. As you said, put it to bed, and then it's just there. And we just continue, we will just live our lives without the threat of something being in the background that's just a bit unfinished. I just want to thank
Yeah.
you today, Katie, so much for joining us. I know that your time is very precious. And if anybody would like to contact Katie, you've got her details there, or it'll be linked to this podcast. Thanks ever so much for Katie for being a part of our podcast, Three Questions, and have a lovely rest of your day.
Thanks a lot, then, Fiona. Thank you.
Thank you. Bye.
Bye.